Alright. Court's appeals. Precedent. Let's make this one stick. Yeah.
Got a claim, gotta know where it goes. 4 tracks, 4 numbers, everybody knows. 10,000 small claims, keep it simple, keep it small. 25 fast track, moving quicker through the court hall. 100 intermediate, up to that's where it stays. Over 100 multi-track, claims get the biggest stage. And if it's over 100K, high court's normally the way. But personal injury has its own line. 50,000 is the high court sign. And the high court's got 3 divisions, 3 names you gotta know: King's Bench, Common Civil Claims, Chancery, Land Trust, Wills, Family Proceedings. Now watch the hierarchy flow. That's the way the system goes. 3 types of offense, 3 things to recall. Summary only, magistrate's court. Either way, mags are crown. If the defendant agrees, mags can keep it down. Indictable only, crown court. That's the criminal court route and the magistrate's maximum. Don't forget these numbers when they come out. Either way, 1 year. Summary 6 months. Say it once, say it twice. Those numbers could save your life. Solicitors can represent in a county court, even newly qualified. That's the thought. But crown court, high court, you need high rights to appear, to issue an advocacy assessments before you can represent. Civil appeal, follow the ladder. District judge, circuit judge, high court, court of appeal, Supreme Court. The stage of AC stats, that's the civil appeal. Where you start determines where you go. More permission comes before the show. First that's the court that made the decision. If they say no, that's the appeal court for permission. Real prospect of success, or another compelling reason. Those are your gateways, that's your permission. Power straight to crown, defendant's right, conviction or sentence, bring the case to light. Pleaded guilty, there's a limitation. Sentence only, that's the situation. For rehearing, when you reach the crown. But max the high court is a different route now. Wrong in law, ultra-vires, 21 days, written application required. Legal arguments only, no rehearing of evidence. For fraud to court of appeal. Convictions entertained, that's the deal. Conviction, unsafe. Sentence, remember 3. Wrong in law, wrong in principle, manifestly excessive. Wrong, excessive. And if the court of appeal is where you're at, Supreme Court comes after that. Permission, point of law, general public importance and certification. That's the Supreme Court door. Now we're talking precedent. Let the old decision stand. Stare decisis, let prior decisions stand. High courts bind lower courts, that's vertical in effect. And some same level courts can bind too. That's horizontal, don't forget. Court of appeal generally binds itself. Civil cases follow that rule. Criminal court of appeal can depart if the earlier decision was wrong. That's the exception to the rule. High court can bind itself when acting as an appellate court, but not when acting as a trial court and the Supreme Court. This is the bit you need to know. Once the order's independent, it's the part essential to the court's decision. Obiter, dicta, persuasive, it's not necessary to the court's decision. Once you've been, don't have to go. Don't have to be. Don't have to go. Yes, and it's one down when the facts and law are similar and who's speaking matters too. Majority bonded, minorities bonded. I know that you said that the sword persuades. to the low. Supreme Court free to go. It's courts of gears, Precedent 2. If you get Senate, you get SQE1.